State of Michigan versus George Gillespie, case number 22 FB 1625.
Rachel Duffy for the people.
Assistant Public Defender Sandra White on behalf of George Gillespie.
Yes, ma'am.
Please state your name, Mr. Gillespie.
George Gillespie.
Thank you. We're supposed to be here for sentencing today, but it appears that he did not keep his second appointment to have his PSI done. And the recommendation is to remand to get this PSI done.
Yes, Your Honor. And I did have a breakout room with Mr. Gillespie, and Mr. Gillespie is very confused about the process. And it took me a little bit to explain things to him. He thought just like he will get a text or email like he does for the Zoom link for probation. I explained that the judge
I explained this to him back in October when he was here for the first time that he missed his appointment.
And I explained that you give him all the information in court and that you're going to be upset because you do tell him everything in court and what to do, and normally tell everybody within 24 hours to call probation. I gave him the probation number again. I explained what to do, and he's asking Your Honor to please give him one more chance.
We did that last time. Ms. McDuffie?
Hello.
And you, pardon me, Your Honor. I don't have anything to add. My notes show exactly what the court just stated, and I'm not sure what he's confused about. Quite frankly, nothing from the people.
I was confused about the number. Like when I got the number, I never got the number. I got the Zoom link and I got like a number for court. I never got the actual probation number now she just actually gave me the probation number. I got to save it on my phone now. Before I just had the court number. And the day I was supposed to come to court, which is today.
Bench warrant to issue. No bond. So you need to turn yourself into the Washington County Jail. I give out the phone number each and every time to everybody, and I ask them if they have it. So I'll see you.
Okay.
Will you hand me my screen box?
All right, this is file 232155FY, People versus Lateria A. Walton. Miss Walton, can you hear me?
Yes.
You're in the bathroom somewhere. Where are you right now?
At my house.
All right. Why aren't you here?
Because my ride ignored me and didn't come.
All right. Well, I could have got you a bus. You're charged with home invasion, second degree, and assault and battery. It's alleged to have occurred in July of last year. You have a jury trial set in front of Judge Pattison for next Tuesday. Your lawyer, Melissa Halleck, is here, and she's been here since 8 o'clock this morning, waiting for you. Did you talk to her before today?
I talked to her at my last court date.
All right. What are we doing here this morning, Melissa?
I did speak with Mr. Marvin with regard to her case this morning. He indicated that it was a different offer than what had previously been offered at her other PCC, that he was not offering a misdemeanor, that with the upcoming trial and now this new assault case, that he would not be, that it would be home basically as charged, that she needs to waive a prelim to preserve some sentencing, possible sentencing negotiations upstairs to avoid possible prison.
All right, so would you like me to simply set up for a preliminary examination for next Tuesday, and you and she could discuss it further?
Yeah, because I do think there's going to be further negotiations with that upcoming trial as well that may change things. I would assume that they're trying to resolve both cases. So, and I've not been able to convey to Mr. Truckee either the changes in the circumstances of my case, which is he represents from that jury trial.
All right, I'll set this for preliminary examination. December 12th at 1 o'clock. Miss Walton, it's your obligation to be here next Tuesday, December 12th. You can't phone it in. You're gonna have to be here live. So if you need a ride, you let me know and I'll get you a bus pass. But this is a felony charge. It's not a traffic ticket. You need to be physically at court. You also have a case next Tuesday. Have you talked to your lawyer, Mr. Truckee?
Yes.
And what Melissa discussed is perhaps they could resolve both cases at once. They're going to bring in 30 or 40 jurors next Wednesday for that trial unless the case is resolved. So your obligation here is to be here next Tuesday, December 12th at 1 o'clock. Tuesday, December 12th, 1 o'clock. Your jury trial is the following day, December 13th. So you need to stay in contact with both of your lawyers. They're working with the prosecutor to see whether they can resolve this. So you're here by Zoom. That's good enough for this circumstance, but you have to be here live next week. You understand?
Yeah.
Do you have any questions?
No.
All right, you look quite bored and indifferent to all this.
I'm
These are
not
very-
bored. I'm going through something, actually. Thank you.
All right, well, you're going through something, all right. You have a felony charge pending.
You're
So,
trying to be funny. It's not funny.
no, I don't think it's funny at all.
You're smart remarks. You're acting like it's funny. It's not funny. Like, yeah, you're a judge. You probably don't go through the stuff that we go through. That's not what I'm going through. That's not the only thing. But okay.
All right, it's not the only thing you're going through, but this is more than an inconvenient nuisance. It's a criminal charge with a serious consequence. So I want you to stay in contact with both of your attorneys and physically be here. If you need a bus pass, you tell me and I'll get you one.
Thank you.
All right. All right. She's going through something. All right. I guess we all are going through something, but we'll deal with this. Good luck trying to shepherd all these two cases together. She's entitled to have a prelim if she wants. She's entitled to have a jury trial if she wants. So thank you, Melissa.
Okay, thank you, Judge.
State of Michigan versus Eric Martin, case number 23-00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Eric Martin.
Mr. Martin, please unmute, state your name for the record.
Can you hear me?
Yes, sir. Please turn on your screen also.
What's going on? Hold on, I'm trying to do that here. I'm not seeing it. There we go.
There you go, sir.
This is Eric, capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N, living man, hereby threatened arrest, and appearing by special appearance of a general jurisdiction.
Thank you, sir. This matter is scheduled for a pretrial today. I received a letter from Mr. Martin that was forwarded to the prosecutor's office indicating that he was not able to open the discovery that was provided to him and requesting that he get another copy so that he could try to get it to work. He indicated that he had tried to go to the library in order to get it to work with no success also. And since that time, Ms. McDuffie, were you able to provide him with another copy?
No, Your Honor, we have not provided another copy. So the issue, I think, is that Mr. Martin, first of all, let me just confirm that when discovery was demanded and ordered at the October 26th final settlement conference, obviously he received it. He picked that up on November 7th. That contained a flash drive with the media, which is MSP WatchGuard video, a copy of the police report, and a copy of the citation itself. So Mr. Martin has received everything that we would provide to any other attorney, except that it's not a link because he didn't give us an email and he wanted it mailed to him. But what often happens is that to be able to view that, you need to possibly install a player on your local computer so that you can, play that video. And if Mr. Martin is going to the library, it's most likely a system that's not going to allow him those types of permissions to do that. So I would encourage that we don't really have, it's not an issue, I don't believe, with what he was sent having some sort of error on it, but I think that he should connect with his standby counsel because the PD's office would likely be able to assist him in viewing that.
Thank you, Mr. Martin. So what she's saying is you have to install a particular application called a player to be able to play that. It's not going to just play on its own. You have to have the downloaded app or whatever it is that you need to play it from that. Download it to your actual computer. When I was a defense attorney, the way we had to do it is to download that player as well. That's the way the process works, sir.
So I don't know. I don't understand how to do that. And I object to her saying it's not nothing they sent. It shouldn't be this complicated. It should just be able to review it.
Well, that's how it works for everybody, you and every other attorney, sir. So what she's suggesting that you do is to get with Ms. White, who is your standby counsel, and have her assist you with downloading that so you can review it, sir.
Well, as I objected to before, I don't accept no attorneys because then that would give unlawful, fraudulent presumptions, and I'm a defendant, and along with a lot of other presumptions, which I'm going to be sending affidavit to rebut 12 of the general fraudulent presumptions that's done in cases. Haven't did it yet, but yeah, that's the problem with that.
Well, that is your choice, but that is the mechanism for you to review it. You can utilize what is available to you or you cannot, but those are your choices. I'm going to give you one more chance to figure out how to get that done. If it's not done at the next pretrial, then we'll just keep moving forward. Okay?
Well, no, I objected. Well, I need to be able to.
You can object to whatever you want to object to, sir, but that is what we're doing today. Pretrial in this particular matter is going to be adjourned to February 1st, 2024 at 9:00 a.m. We will see you then.
Hold on, let me write this down. So February 1st?
Correct.
At what time?
At 9:00 a.m.
9:00 a.m. Okay, now this lady you're talking about, what is her name again? I don't have her number or nothing.
Sandra, I'm sorry.
There you go.
Sandra White. It's on the screen there. Can you see it?
Yeah, I see the name, but I don't see no number or nothing. And
Okay. Will you answer our calls? I'm gonna give you the phone number. You ready? I'm
yeah,
gonna give you my office number: 734
yeah,
545
yeah.
3486.
3486. All right.
Okay.
I just wanted to Washington object again to her representing me because, like I said, I'm always of the position to present myself as a man, so I'm not going to give up my right to do that. But but I will contact her if you guys are going to force me, so to say. It's only going to be by force, and not give me no other option to review the video myself due to them not sending something that can be reviewed. But that's all I got to say on that. Like I said, it'll be by force. It's not they're not giving me no other option. So
All right. Thank you, sir. Your objections are noted, and I'll see you back here on February 1st at 9:00 a.m. Okay.
Okay.
Thank you. Take care of yourself, sir.
I will. You too.
Bye-bye.
Bye-bye.
Bond is continued.
Okay, we are on the record in the matter of the state of Michigan versus Kevin Smith, 231353. An appearance for the people, please.
Good morning, Your Honor. Omar Shasha on behalf of the people, PH 6332.
Thank you.
Good morning, Your Honor. Edward Taylor, P-Files, number 166, appearing on behalf of Mr. Smith.
Thank you. And Mr. Smith, can you please state your name for the record?
Kevin Francis Smith.
All right, thank you, and good morning. And
Good morning, Your
today
Honor.
is the date scheduled for a review. And the court had rescinded the order of criminal responsibility on November 9th. However, I don't believe the Center for Forensic Psychiatry received that time in time prior to them sending us their communication, which indicated based upon Mr. Smith's determination of incompetency that they could not perform, they were not able to comply with the order to delegate for criminal responsibility. And counsel, did you each receive a copy of the report from the Center for Forensic Psychiatry?
I did.
Yes, Judge. The people have received that report, Judge, and we do stipulate to the findings of the Forensic Center.
Okay, so this indicates that Mr. Smith has been opined incompetent to stand trial, likely to attain competence if provided with a course of treatment within the time limit established pursuant to statute.
Were you talking to me, Your Honor?
No, I'm just making a record right now, sir. And the court will note that both counsel have stipulated to the report, and the court is going to state for the record, based upon the stipulation of the report and the contents of the report, that Mr. Smith is deemed incompetent to stand trial.
Your Honor, my biggest thing is, I know you're
Excuse me, sir.
pushing towards the medication, but the kid.
Please do not interrupt me right now. Mr. Smith, right now I'm making a record. You cannot interrupt me right now, okay, please?
Okay.
That there's substantial probability that Mr. Smith could be expected to regain competency within the time period provided by statute if he's provided a structured inpatient hospital setting with provisions for appropriate therapeutic intervention, including compliance with medication management.
Excuse me?
The court is going to order that Mr. Smith receive treatment within the structured inpatient hospital setting and is to receive appropriate therapeutic intervention as well as medication management. And so,
that's no good, Your Honor. The medication, I don't need the medication.
Okay, and so the court, we cannot continue at this point with this case.
Understood, yeah.
And we will set this for a review to make sure that Mr. Smith has received a bed and treatment so that he can hopefully get on his path to competency, and if not, have another path. Anything else for the people?
Nothing for the people, Judge. Thank you.
Anything else for the defense?
No, Your Honor.
All right, so counsel, there is an order regarding competency that I'll need you to prepare and submit. It's a scale form. So if you can submit that within the next couple of days, that way we can.
What do you need me to do, Your Honor?
The order regarding competency?
Okay.
Yes. And then if you'd like, if I would like for you, counsel, to include the specific language regarding the the structured inpatient hospital setting, so the last portion of that paragraph, please.
Very well.
And then we'll set this for a review. Let's do February 29th. If the court order bonding conditions are continued. Anything else? Okay, Mr. Smith, I hope that you're going to receive the treatment that you need, sir.
And what treatment would that be?
Your mental health treatment, sir.
Oh, there's nothing wrong with my mental health.
Okay.
We have another.
All right. Have a good day. Thank you.
Thanks, Your Honor.
All right. Are you Tanya Marie Yoder, now known as Tanya Marie Moeller?
I am.
Mohler?
Correct, Your Honor.
You got charged with larceny by stealing an alleged wallet containing $180 in cash that belonged to Richard Roll. And that happened in March of 2023. That is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. The warrant was issued in May. You got arrested in November. You came to court and you pled not guilty that day. We weren't available to do a pretrial right at that time, so they set the pretrial for this morning. Met with Mr. Marvin, the county prosecuting attorney, and he says you're going to enter a plea to taking that man's wallet. Is that correct?
Yeah, I picked it up out of the basket.
All right. Well, you heard me go through the advice of rights with the other person. You understand you have those same rights?
Yes.
Did anyone threaten you to get you to plead to this?
No.
Or promise you anything?
No.
All right. Everything seems to happen at Walmart. Were you at the Walmart store on March 31st?
Yeah.
And this Mr. Roll left his wallet in the motorized cart?
Correct.
And then you came upon it?
Yep.
Tell me what happened.
I come up on it. I was headed for my vehicle, went to the vehicle. My son and his friend were in the vehicle at that point. It was in my son's possession, so I admit to taking it out of the basket. After that, it was out of my control, and yeah.
All right. Do you know whatever happened to it?
Do not.
The wallet? The wallet was thrown, she threw the wallet in the garbage can.
No, I did not. That wallet did not go in that
Very
garbage.
well, yeah.
No, that wallet did not go in that garbage can. That wallet at that time, when I drove out of that Walmart parking lot, was in my son's possession, not mine.
It wasn't me. I even had her in the shower. It wasn't me. She even caught me on camera. It wasn't me.
So unless the man has his stuff back out of that trash can, it was not put in that trash can. That's hearsay.
Your Honor, I wonder if it's worth our time.
Yeah.
Doing a PSI. There's a video.
Yeah.
Maybe she can remember what she threw.
She told me she took it, so that's sufficient.
I did take it.
All right. You're not the least bit repentant. It's like, well, there's a video of you throwing this thing in the trash. So I guess we'll set this out for sentence and we'll take a look at the video. But it doesn't matter. The guy's out $180. You took it, you gave it to your son. He bought who knows
get
what.
it to nobody, but
Well, what did you didn't give it back to the guy that owned it?
well, yeah, I tried. And I have a child who is off the wall. I can't even get a PPO against my child in this county. So yeah, once I got to the car with it, I was threatened. So what you see me throw away was trash that my son piled in my seat. When I put my purse and that down, then he copped onto it. Oh, what's this? Well, finders keepers. Well, that's not how his mother works. I've never been that way. I have a very clean record. other than child support and
All right, well, slow down. I'll take a breath.
no, I'm just over everything that's happened in the past 6 months with my kids.
Everything happens to me.
Now, your name was Yoder and it became Moeller. Did you get married to Moeller or did you?
Yes, I remarried. I divorced in 2012. I divorced Raymond Matthew Yoder.
So your name's been Moeller for a number of years.
Yes.
Okay.
It just shows up in this county because I was a foster parent for 10 years under Judge Shoemaker and community mental health.
All right, let's bump this out and I'll take a look at things. For one thing, we're gonna have to give this guy his money back. You're gonna have to pay $180
And that's fine.
restitution no matter what happens. So that would be helpful if you brought that with you when we come back to court.
I will be over before that to pay it.
All right, let's take a look here. Let's set this for sentencing at 10 a.m. on Wednesday, January 17th. And I'll watch the video in the meantime. I'm watching one for this morning. All right, you're free to go. I'll see you on January 17th.
The state of Michigan versus David, step 232404.
Morning, Your Honor. Tax dot P82492, appearing on behalf of Mr. David Stepp to my left, name for the record, sir.
David Andrew Stepp.
All right, thank you. And today is the date scheduled for the preliminary examination. And Mr. Chandra, can you please place your appearance on the record?
Good afternoon, Your Honor. Omar Shafir on behalf of the people, PA6332.
All right, thank you. And today is the date scheduled for the preliminary examination in this matter and counsel.
The people are moving to dismiss based on insufficient evidence.
Counselor, can you approach, please?
Yes.
Off record. All right, so we are back on the record in the matter of the state of Michigan versus David Stepp. And all right, and counsel.
And Your Honor, the people moved for insufficient evidence because the evidence in this particular case would have likely been suppressed by this honorable court based on the People versus Pagano, which is the state of Michigan court case from April 22, 2021. That's 507 Mich 26. In the People versus Pagano case, Your Honor, there was a 911 call with respect to a potential person driving under the influence. The police effectuated a stop on that defendant without visibly seeing any reasonable belief or probable cause they had committed any traffic offenses. That particular case was dismissed at the district court level, citing that the evidence would have been suppressed under United States, Terry versus United States, and also under our Michigan Constitution and People versus Custer. The prosecution in that case appealed the case to the Circuit Court of Appeals, where the Circuit Court of Appeals, Your Honor, reversed the case, where afterwards the Michigan Supreme Court gave the defendant motion to leave to argue the case, which was argued by the people and Dana Messel, the Attorney General. In the Michigan Supreme Court case, the court justices all ruled in unanimous decision that a 911 call is not sufficient to effectuate a stop because it is tendered anonymous in nature. The officer, if responding to a 911 call, particularly in a driving under the influence case, they must visually see some sort of corroborating evidence, reasonable belief. They don't even need probable cause, they just need reasonable belief, but it must go above and beyond the 911 call. And the court quoted, Your Honor, the court quoted that the officer should have seen a swerving, a traffic stop, even an inference of a traffic violation in order to effectuate a stop. Cannot be on the 911 call, Your Honor. And if you'd like me to apply that to the case here, the defendant was followed for 11 seconds, made no traffic violations, 11 seconds, and he was pulled over, based only on the 911 call. And for those reasons, that evidence was suppressed, the Michigan Supreme Court feels the same way.
I rest my case.
Okay, any response, Mr. Chandra?
Nothing for the people.
Okay, all right, the court will grant the people's motion to dismiss based upon People v. Pagano and the facts in this case. And sir, let me just be very clear with you. You have an issue with alcohol consumption. You may want to tell the court no, but I would bet that you don't only drink alcohol 3 times and then happen to have police contact all 3 times. So you might want to really should probably take a look at your lifestyle and what you're doing with that as it relates to the alcohol, sir. Since this matter is now dismissed, sir, then the terms of bond conditions are going to be terminated. So you'll have to stop over probation so you can get information as to how to get the tether removed. And then just make sure we have all of your current information, sir, so that you can have your bond returned to you via mail.
Yes, ma'am.
All right, thank you. Have a good day.
Thank you. Happy holidays.
All right, we're going on the record in the matter of Stephen Cleaver, 23841.
Right, Good afternoon, Your Honor. I'm Neil Lloyd, P36827 here on behalf of Stephen Cleaver, who stands to my right.
Your name, sir?
Stephen Daniel Cleaver.
I think you change the date schedule for probation violation. Mr. Cleaver is currently on probation for domestic violence, and it's alleged that Mr. Cleaver violated probation by continuing to contact the victim in violation of the condition of probation of no contact, and that contact would have occurred on November 29th and December 3rd. And counsel?
Your Honor, my client is willing to waive his right to a hearing today and admit to the conduct alleged in the matter brought forth by the probation department.
Okay, let me also clarify that this also appears to be a jail review also.
I don't know that, Your Honor. I noticed there's a notation in the file that the jail review was scheduled for the 11th, I think.
Oh, I'm sorry. No, the 12th is not today. That's the 12th is.
The 12th, yes. No, today's the 7th.
Yes. Yes. Yeah. So the 12th is next Tuesday.
Right, and so we're prepared to address the matter of the bond violation, conviction violation.
All right. Sir, please raise your right hand. You solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. And sir, you heard the allegations for with this regard to the probation violation, correct?
I do.
As to the allegation, sir, and that you violated probation by contacting the complaining witness in this matter, how do you plead?
I do. I did.
Okay, how do you plead? Guilty or not guilty?
Guilty.
Okay. And you have gone over your advice and rights for probation violation purposes, correct?
Correct.
And you understand all of those rights?
I do.
You also understand by entering into a plea so that you'll be waiving some of those rights, specifically your right to a contested hearing.
I do.
You also understand the possible penalty as a result of your plea.
I do.
And the recommendation in this plea, or in this matter, is for probation to be revoked, the case to be closed without improvement, $50 probation violation fee, 45 days jail. You understand that?
I understand that, Your Honor.
And you also understand that by entering that this court could adopt that recommendation in whole, in part, deviate from it completely, correct?
Correct.
All right. And knowing all that, you still want to continue with your plea?
I do.
All right. And counsel? Oh, I'm sorry. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Sorry. Yeah, he has a bit of a hearing. I think.
Okay. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right. And counsel, you please ready your client.
Yes, Mr. Cleaver, you understand the charges against you today?
I do.
And the allegations made by your wife are that you contacted her on 2 separate occasions by text.
I do.
And then the file, there's photo, looks like what are called screen captures of a couple of texts that were sent to her recently.
Yes.
You acknowledge that you did send those texts?
I did.
And you realize now that that's a violation of the...
I realize it now that it's a violation. Since then, taken the phone numbers and any photographs.
Counsel, can you please have a conversation out the lobby, please? Thank you.
I've taken any and all photographs that I had of her and her phone numbers out of my phone completely.
Right, if I could address
I'm sorry, did I just hear your client say that he didn't know? Is that what he just said? Is that what you just said, sir?
No, Your Honor.
No, go ahead.
I said I do know, but I have since then taken all of her photographs and phone numbers out of my phone. It was a social media deal, and my mistake.
Your Honor, if I may address the court on this.
Yes.
Certainly you know this case very well. He's been before you numerous times. He's been married to this woman for a long time. This is his wife. Divorce is still pending. There's mediation coming up in a couple of weeks. He's been diagnosed with major depressive disorder. A report has been provided to the court. He's involved in teen wellness. There's a positive report in the court in the file dated just a few days ago that he is continuing to continue in his treatment there. Advises that he is completely abstained from alcohol since the spring of this year. Yes. So we're going on roughly 9 months of sobriety. He knows he messed up here. He's not trying to deny it, but we do need to put it into context. You know there are many cases where people in violation of your order, they'll drive by the ex's house. They'll send stuff to the ex's house. They'll do terrible things in violation, just completely ignoring the probation. He sent 2 texts. He did that. He's now taken steps. He deleted the phone. Whatever depressive condition he may suffer in the future, that'll make it a lot harder. But again, in the scheme of things, he's not threatening her life. He wasn't intentionally inflicting distress on her. He understands, I believe, he understands that even though he didn't intend to inflict distress, he did. It's very clear. She doesn't want contact with him. And you read what he texted her, it's an apology. And I don't know, I'm not a mind reader, but it seems like a sincere apology. He should have done that. But he isn't threatening you, why are you doing this to me? He's not playing the victim. He's acknowledging that he did, he's responsible for the situation between him and his wife. I just think that taking that into consideration and considering what could be a probation violation, there's no violence, there's no threats of violence, there's nothing like that. He shouldn't have done this, but I think that under the circumstances, this could be an excusable violation. That's something that we're asking the court to continue his probation. Another point, again, this is not the court's concern, but when he was incarcerated previously, he discovered that immediately his sole source of income, Social Security disability, terminated. And knowing he had to reapply for Social Security after he got out of jail. Also, he lost his Medicare, which means the teen wellness treatment, no more funding for that. His medications, he's on a number of psychiatric and other medications. Funding for that immediately gone, which is, he will suffer great repercussions from that. So it's in his best interest to 100% abide by this court's restrictions. And I believe he understands that. So again, we'd ask the court to make an exception, excuse this violation and continue his probation.
Well, and because I can appreciate that the messages that your client sent were not of a threatening nature, specifically. However, she doesn't want contact. And by contacting her, not only are you violating this court's orders, but you're not respecting her boundaries. You're not respecting any of that. And while you may not be threatening words in your messages, that doesn't mean that she isn't taking that in a threatening manner. Does that make sense?
It does, and I apologize for that. It'll never happen again.
Sir, I hear what you're saying, but this is not the first time that you violated this court's no contact order. In fact, you were contacting her from jail.
That's when I was first locked up.
Right, you're contacting her from jail by phone, and then you were mailing stuff to her. And then I think, if I recall correctly, you contacted somebody You contacted somebody to contact her even. So you go to a lot of different lengths to contact her.
That was a long time ago, Your Honor. I'm over all that right now. The divorce mediation is the 18th, and I've accepted that. I've accepted the fact that she wants nothing to do with me anymore.
But yet you still contacted her. Asking about, is Maggie a dog?
There was a dog that we used to babysit. It's a pastor's dog. And I recently contacted my pastor and talked to him. And he told me that the dog was still alive. The dog's 22 years old. And I had just put a comment and a picture out on social media, which I shouldn't have done.
And was there, what was that one?
I'm sorry, Matt?
What was that comment on social media?
I think he's referring to the text.
I'm referring to the text.
Court also, at the time of sentencing, in jail for any violation. This court did suspend 38 days for your client instead of jail reviews. And counsel, perhaps if this was, a one and done, there'd be a little bit more weight given to your client's statement that, he won't do it again, he won't do it anymore. But this is, I think, 4 or 5 times.
Your Honor, would the court consider community service involved?
You've already had your under advisement status revoked, sir, from your last violation. And that's because you were driving by her home. You were in the exclusion zone. You were driving by her home, if I recall correctly.
That was a long time ago, Your Honor.
August 2nd.
I'm sorry.
That was July, because the hearing was in August, I believe. Well, the court's going to enter a probation violation based upon your plea of guilty. The court will accept your plea. The court's going to revoke your probation. So I can appreciate that you are receiving mental health services. I think that that's long overdue, so that's good to hear and see. And I did review that paperwork as well, counsel. Why was it so important for you to know if Maggie was still alive? If the dog was still alive?
Why was it so important to me?
Yes, that particular day. Why did you need to know that?
I just think it's a miracle that the dog is still alive.
Well, it's your pastor's dog. You said you spoke to your pastor. Why didn't you just ask your pastor?
I did talk to my pastor.
So why did you then have to ask Kathy if the dog was alive?
I didn't ask her. I just commented that the dog was still alive.
Is Maggie still alive?
That the dog is still alive.
Yes. Well, that's a question, sir. And then she didn't respond. And then you send her another message a week later. I hear Maggie is still going on. God bless her.
I was talking about the dog.
I understand Maggie's the dog. I understand that. I miss you all. If you wanted to find out about the dog, ask the pastor. You spoke to the pastor. You didn't have to contact her at all.
No. Made a mistake.
Probation's revoked, 45 days jail. And then the court's going to cancel the jail review for Tuesday.
Would the court consider this?
Oh, come on!
Is amending the jail. I understand that if the incarceration is for no more than a 10-day period, his benefits would not be terminated. So I know that's a big step, but I think it's important that he be able to continue to get his medications and his psychiatric treatment.
Well, I would agree. I mean, so are you asking to do like 4 10-day terms?
Mr. Cleaver, is that what you're asking? Would that be better for you?
Yes.
Yes, that is what we're asking for. That.
Are you fucking kidding me?
With the court's indulgence, if the court can arrange it in that fashion.
I don't know if that's a thing. I don't know if that's even a thing.
It might be unique. I don't know.
Oh, it's definitely unique. We can make a phone call down to the jail to see if that's even a possibility, but I don't know that it is. I think that you may have to go through the process again. I don't know. But at the end of the day, I mean, we can make as many accommodations as we can, but your actions are why you're here in this situation, because you contacted her again, twice.
Bingo!
No contact is no contact.
I understand that.
And sir, with all due respect, you've said that every time that you've been here regarding that.
I didn't feel that a text was contact, but I'm wrong.
Well, what did you think that was, sir?
Just a message over Facebook.
One more suggestion, Your Honor. You send him to jail for 10 days, he can maintain his benefits. If you not revoke his probation, there's a benefit to the complainant here. But we still have some authority over him going forward in case there are any additional contacts, which he assures us there won't be, but the court would have some control over that. I wouldn't require her to file a criminal complaint or anything of that nature. He would already be subject to it. I think there's no logic there.
Well, there is some benefit to that, but at the end of the day, Mr. Cleaver continues to violate the same condition of probation. And sir, I'm very, very positive that I stated you're not to contact her. No contact is no contact. And I can tell you what I said because I say it all the time. That means phone contact, text message, email, social media, third party, anything of the like. And I say that every time, so I know, and that's the order I typically 99% of the time say it in.
It'll never happen again. I give you my word.
That's not true. He is so full of baloney.
Well, it's not going to happen for the next 45 days, I can tell you that.
And mic drop.
Counsel, I understand what your request is regarding the 10 days, but I don't know that the 10 days is going to be sufficient. I mean, he's spent 55 days in jail before on this matter while he was awaiting the resolution of the case. So at this point, I'm going to continue with this court's order. Counsel, if you want, I'm going to I'll step off in a couple of moments after I handle these other two cases and inquire about the jail, the 10 days. Then I'm also going to consult with Ms. Shine, and if she has more contact with the complaining witness than I do, to try to gauge whether or not she would have any amendment in her recommendation, which I don't know that she will. I'm not suggesting that she should, but.
Thank you.
All right. Okay, we'll recall this matter in a few moments. All right, we're going back on the record in the matter of Stephen Cleaver, 23841.
Your Honor, Joseph Lloyd, Stephen Cleaver, B3687.
Okay. And so the court has taken into consideration counsel's request to amend the days of jail and continue probation. The court has taken into account a few things as relates to that request. In communicating with Ms. Shine, who's been in communication with the complaining witness, she just wants to be left alone. And counsel, you're correct. One way we can accomplish that is for Mr. Cleaver to continue to be on probation we could effectuate it without him being on probation as well. However, she would have a little bit more instant gratification regarding results if your client remains on probation as opposed to having to file a complaint and a police report and things of that nature. So the court's going to amend its order. The court will continue you on probation, sir. You're going to complete all terms of probation. You are also going to serve 10 days jail, so you can not have any negative ramifications regarding your disability that you just worked back out.
I know, I was speechless too.
You can attend your mediation. And counsel, some of that was predicated on the fact that your client has made improvements regarding his contact, so to speak. I mean, he knew not to go to the home to get his clothing he needed for winter, or allowed the attorneys to arrange it, things of that nature. So that's what the court's going to order. So, sir, you're going to start your 10 days today.
Thank you, Your Honor. Appreciate the consideration.
And the jail review is still canceled. So you don't have to worry about that for Tuesday. Okay. Have a good day.
Thank you, Your Honor.
All right, have a good day. All right, off the record.
What just happened?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. The day is a joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're gonna start bringing people in court. People will learn how to act in a courtroom.
Can you hear it? Can you hear it? Man? Man? Can you hear it?
No, I know.
Okay.
I have no patience for that. Trust me, out of the day, I'm sitting up here, I'm the one that sees the drink.